I cite here the Nazi Aryan trustee law that empowered lawyers to do that. And as Getz Ali notes in his book, Hitler's Beneficiaries, during this period, at least 9% of the Nazi total government budget was stolen from Jews. And that's a significant amount. It's still our public policy in the United States that this property should go back to the people from whom it was stolen. The Holocaust Victims Redress Act of 1998, Congress reaffirmed that, and I cite the language in the materials. But I want to go back and talk about why it is that we ended up with so much stolen property in our museums. And we really have to take a hard look at American museums and our cultural tradition to understand why. So let's start with the great robber baron, J.P. Morgan. Morgan had a huge collection of European art that was fabulous, and he said, I'm not bringing it back from Europe for American museums if you're going to make me pay taxes on it. So Congress and pliant Senator Aldrich was part of passing the Payne-Aldrich Tariff Act of 1909. And that act added imports of original artworks from Europe that were more than 20 years old to the duty-free list. So that paved the way for the creation of some of our greatest museums. The other thing that is a primary motivator in building museums and the prominence of American museums, because we treat our museums in America better than any other country does for tax purposes and cultural purposes. Andrew Mellon got a big tax bill from the Roosevelt administration back when the income tax was a rather new and controversial thing. And Mr. Mellon said, no, Mr. Roosevelt, I don't owe you any money. I gave these very valuable artworks to the National Gallery, and I should be able to deduct the fair market value of those artworks. And there was a big squabble over it, and Mr. Mellon won. And Mr. Mellon's victory is enshrined in today's tax code that says you get a fair market value deduction for a work of art, regardless of what you paid for it. Now, the significance over most of the 20th century is that if you're wealthy, you could avoid capital gains tax by donating to a museum and thus shelter almost all of your income from taxation by making donations of appreciated works to museums. The translation is that if you're really rich, you've got to find ways of sheltering your income from, at times, it was a confiscatory tax regime in the United States, particularly after the Roosevelt administration. So people scrambled, and they figured out if you're really, really rich, you probably need your own museum. So that accounted for the proliferation of museums in the United States. And today we have really what are considered the world's greatest museums, the greatest collections of European and other artworks. And that's an ethical and social choice. You know, when we think about tax fairness, people who give to museums are not giving to others in our community. They're not paying for schools or housing or roads or most of the things that other people in the middle class are paying for. This is a social choice that we make in our tax code. So the ethical question comes up is, well, okay, that's fine if people are donating legally acquired art, but it becomes much more problematic when they're donating stolen art, and none of us are really scrutinizing those donations, particularly when we see that today in America, there are more museums than there are Starbucks and McDonald's combined. And we go back to saying why. People want tax breaks. So there's articles in the New York Times about some guy has a museum in his backyard, in his barn, that the public can see every third year for 15 minutes. You know, every time there's a tax loophole, somebody will try to drive a truck through it. And, you know, that's just human nature, that every time there's something out there, we're going to have a group that abuses it if we're all not vigilant. So the Monuments Men, if you watched it or read it, you thought, well, these are these great heroes. And to, you know, to a lot of extents they were. But they came back from Europe, having seen all these wonderful treasures. And they looked at their podunk towns and they said, we have these lousy collections. And they all started competing with each other. And they got the wealthy people in their community and they say, we are going to be better than Pittsburgh. We are going to be better than Boston. We're going to be better than. And they went out and they found the best artworks they could and they stuffed them all into their museums. And that's what we have. Now, during that time, the whole time, the U.S. government, the State Department, is issuing warnings to museums, saying, don't acquire stuff that came from Europe that you don't know where it's from. So here's an example of January 9, 1943, the London Declaration. We all vow we will undo these acts of Nazi spoliation. We know that the Nazis are engaging in these sham transactions. Don't acquire this through Switzerland. We know what these neutral countries are doing to launder these transactions, and we're going to undo it. That's why we fought World War II, was to return all of this. That's why the soldiers died. This is what they were fighting for. But 1964, front page of the New York Times, Europe is still hunting for its stolen art. Can't find it. Gee, I wonder where it is. Hundreds of millions in treasures elude the post-war search. Yet, as this article reports, between 1945 and 1962, 3,978 stolen art objects were recovered in this country by the State Department with the assistance of other government agencies and returned to 14 nations overseas. That's a lot of door knocking in Middle America to recover stolen artworks. Messages went out, bulletins from the Department of State, to universities, museums, libraries, art dealers, booksellers. They asked everybody, please, this is our duty to the world community to return these stolen artworks. If you know anything, please tell us. And these missives went to the most educated and trusted people in our communities, asking for their help. During this whole time, after World War II, there was the National Stolen Property Act in place. So it was always a crime to receive stolen property, both a federal crime and a state crime. But this was it was law that was never really enforced. And we see today, this is a headline from a newspaper in Tallahassee. Painting set to return to rightful heirs. There's an image of Christ carrying the cross from 1542 that the Department of Justice seizes on behalf of a Jewish family to return that artwork to them. So let's look at the current problem today. Philadelphia Museum of Art, like many major art museums, agreed during the Washington Conference to show works in its collection that entered the country after 1932, but were created prior to 1946 and had been in Europe, because this would enable Jewish families and provenance researchers to identify objects that potentially could be returned to families. So if you go to most of these websites, if you look for provenance or collections, you'll find lists. And here's an example from the Metropolitan Museum of Art. We see that they have 769 records. They stopped, and they don't put in sculptures or graphic works, so their efforts are incomplete. All museums stopped doing that together. But we see a couple of Christ presented to the people, nude by Modigliani, and it'll give some information on that artwork. Here we have a provenance. It's, a bunch of question marks, probably this, probably that. You don't get much more information on that. So these images are still very difficult for families to trace. Gift of Mrs. So-and-so. How does that help you trace where the artwork came from? Art at the Dia. Here's the Dia provenance section. They're touting now. They're going to look and try to establish continuous ownership records. We talk about Nazi looted art, so you can find that information there. And the punchline on this site, we see, it has subsequently been estimated that approximately 20% of Nazi-era looted art remained in private hands and continued to circulate on the market, with much of it finding its way into U.S. art museums. So this is not some lawyer from New York coming here and saying our museums are full of stolen stuff. This is the Detroit Institute of the Arts saying precisely that on their website. How big is the issue? Cleveland Museum of Art director Robert Bergman, now deceased, said, we're talking about hundreds of thousands of objects. I believe for the rest of my professional career, this issue will face the world's museums. 2006, James Cuno, head of the Art Institute of Chicago, tells Congress the amount of research to be undertaken on the tens of thousands of works of art that by definition may have Nazi-era provenance problems is significant, requiring large allocations of staff, time, and money, allocations U.S. art museums have made and will make until the job is done. Morgenthau goes, seizes 2 artworks by Egon Schiele at the MoMA, one of them Portrait of Wally, litigated for 12 years. Finally, Austria settles with the heirs. The other work that he seizes is Dead City. Dead City, remember I showed you the Kieslinger inventory of what was stolen from Fritz Grünbaum? Dead City was on that list. So that was one of the works that Morgenthau seized. But for some reason, Morgenthau, well, I know why Morgenthau let it go. He, as a state prosecutor, litigated up to the New York Court of Appeals that said he didn't have the power to seize those works. So the feds came in and they seized Portrait of Wally, but they didn't seize Dead City. And Dead City was then returned to Austria, and it now hangs at the Leopold Museum in Vienna. So Fritz Grünbaum's heirs haven't gotten it back yet. And this is a catalog raisonné of Dead City 3. A catalog raisonné is something you should know about if you do work in this area. It's a scholarly representation of an artist's work or oeuvre, and it gives very important information on the work's provenance. So the upshot of this 1998 seizure by Morgenthau led to a tremendous international scandal. All countries, 46 countries, came to Washington, had a conference, promised that everything would be returned. Museums told Congress, oh, no, you don't need to pass any federal regulations. Every state's law permits stolen property to be given back. So if something's stolen, we don't need any new federal legislation to assist Jewish claimants to give stuff back because every state's law permits that. But what happened? After the Washington Conference, museums started suing Jews. And they started suing them to keep them out of court. And I want to go through some of the case law that's emerged. And some people are shocked at some of the decisions and some of the positions that were taken by museums. Because think about it. Why do museums need to sue Jewish people? Jewish people are not massing with baseball bats trying to rip things out of museums. There's been no reports of that. So if Jewish people are complaining that they own something, why would you need to sue them? Particularly in the wake of the Washington Conference, where it says heirs are encouraged to come forward, everything should be settled, every nation should have dispute resolution mechanisms. But that's not how the museums went. So let's go through some of the litigation. Here's a good case, one that I like. By the way, I'm a little bit opinionated, and I'm only presenting one side of view tonight, so I apologize for not presenting so much the other side, because I have some pretty strong feelings about it. Weinberg versus Bissonnette. There, the First Circuit affirmed the granting of summary judgment. This was to the Max Stern estate. And in that case, it was summary judgment on a duress sale. Remember, I discussed how certain things were sold under duress, and an expert report was put in, and the judge accepted that an artwork was sold under duress and ordered that it be returned to the heiress, and that you can't just use the word laches to block the return of something that is owned. Now, the really bad cases are two actions. One is the Detroit Institute of Arts involving Vincent van Gogh's The Diggers, and the Toledo Museum of Art Street in Tahiti. And the story behind these two lawsuits is my friend David Rowland is a lawyer, and he represents the heirs of Martha Nathan. And he had a conference in New York, settlement discussion, with a representative of these museums. And he said, well, the Washington Conference, we have to discuss, we're going to settle this, we're going to figure out what the truth is. And they said, oh, no. If you don't, your clients don't give up their claims, we're going to sue you. And he said, you can't do that. You just agreed in the Washington Conference. He said, oh, no, yes, we can. So they walked out of the settlement conference. They issued a press release, and shortly thereafter sued on almost the same day in two separate jurisdictions, Detroit in Detroit and Toledo in Toledo, or Northern District of Ohio. And I'd like to describe a little bit about those cases and how they were decided. Ordinarily, when you file a complaint in federal court and somebody else makes a motion to dismiss, the person who makes the pleadings is entitled, if there are disputed facts, to fact-finding, and we call it discovery. So discovery is a powerful tool that's unique to our American adversarial system, and it ensures that a jury will be able to find, when there's disputed facts, will be able to make those determinations. And that's part of the common law property rights that Abraham Lincoln was so fond of protecting. And here, in both cases, on 12b6 motions, the cases were dismissed with prejudice. And I want to just talk a little bit about one case. Toledo Museum of Art versus Ullin, 477 F sub 2nd, and just to read a section from the decision. In December 1938, the three Jewish art dealers purchased the painting from Martha Nathan for 30,000 Swiss francs, approximately $6,900. In a footnote, the judge notes, defendants refused to acknowledge a sale, citing to the lack of evidence as to negotiation, offer and acceptance, bill of sale, or exchange of consideration, or, in the alternative, the unconscionability of the sale price. Whether a sale occurred is immaterial to the current analysis. Even without a prior sale, there is no dispute that the Toledo Museum of Art acquired ownership through an arm's length purchase from established art dealers. Now, what does that mean? That means that the judge is saying, if you bought it from an art dealer, who cares about whether the art dealer got it legally? Now that flips on its head the common law rule of if there's a thief in the chain of title, no one can take good title. So this is what I would call a really bad decision. This is what I think of as sort of the Dred Scott decision in our area of practice. I can't even believe that it's on the books. And I've spoken to people from Toledo, and they're really in shock and a little bit of denial, and many people said they'd never even heard of this. I go around the world giving lectures on how this is the worst case I've ever seen, and folks from Toledo, it's like, oh yeah, we have a lovely Gauguin, and that was settled. I'm like, no, you took it from the Jewish people, and you sued the Jewish people, and that was really bad. I had a confrontation with the director of the Detroit Institute of the Arts, Graham Beale, and I met him in Prague at the Holocaust Era Assets Conference, and there I said in 2009 the same thing. This is the most disgraceful action of a museum that I'm aware of. And Graham Beale got up, and David Rowland was there. He said, I thought he was going to punch you. And he said, the lawyers told me I had to do it, and he was all red-faced. And I said, well, if the lawyers told you to jump off the Brooklyn Bridge, would you do it? And on top of that, well, fix the problem. Give it back. Publish scholarship. Have scholars look into where this work came from and be public about it. Because history, if you go to the historian's website and look up what history is peer-reviewed research. What these museums are telling us about provenance is not peer-reviewed research. It's just propaganda. They've gone out and promised that they would review and subject to scrutiny the provenance of their collections. They simply have not done it. They're acting really in a bad, unethical way. Another example, museums suing Jews. MoMA and Solomon Guggenheim Museum Foundation versus Schupps. Schupps is a descendant of Mendelssohn, Bartholdy Mendelssohn. Moses Mendelssohn was the great Jewish philosopher, German Jewish philosopher. In this case, Pablo Picasso, boy leading a horse. Bill Paley bought it off the back of a truck in Switzerland. It's one of the great works of the 20th century, modern art, and it's at the MoMA. MoMA sues. Who wins? The case settles. Gross versus Museum of Modern Art, that's my case. How did I manage to lose this one? This is good. Okay, in New York, we have a statute of limitations. It's the demand and refusal rule. The statute of limitations is 3 years from the date of the refusal. And 2 weeks before the 3-year period is up, my clients say, can you sue? So I met them, and we sue right away. So we're 2 weeks under the statute of limitations based on its refusal plus 3 years. No. The judge found an implied refusal because the family negotiated with the museum and engaged in a good faith settlement investigation. The judge said, well, you should have known earlier that the museum's board of trustees was going to refuse. Therefore, I'm going to imply a refusal. Now, this is a federal judge interpreting New York state law. They're supposed to follow the law. Instead, there's a new federal rule on implied refusal. Again, I think a very bad decision that shields the question of whether or not the art is stolen from the discovery process. Another bad decision, Elizabeth Taylor has a Van Gogh. She got it from her father. Again, 12b6 motion on a duress sale. Claim is time barred by the statute of limitations. Now, time barring and statute of limitations in many jurisdictions depends on a legal fiction. The reasonable Jew. The reasonable Jew who is all-seeing, all-knowing, and in 1941 should have known that Toledo or Detroit or somewhere else was either holding an auction or had acquired a work, because no, you weren't busy fleeing Nazis or you knew exactly where all of your family's goods are because Jews are exceptional people. So the reasonable Jew rule that applies in many jurisdictions now, after the Washington Conference, acts to absolutely bar your rights to assert these claims. And again, even better, they invented acquisitive prescription in Louisiana. So just like I said, in those civil law countries, the law is different. So Louisiana, remember, has civil law. So you can keep stolen art if you're in Louisiana, since there was a federal decision in 2010, the Fifth Circuit said that the doctrine of acquisitive prescription will be recognized. Again, these are bad decisions. And in my case, Bachelor versus Vavra, ultimately, the judges decided that my client's forebears, who had fled to Belgium, should have done something to put the purchaser, the 1964 purchaser, on notice. Didn't say what they were supposed to do. So if you're a Catholic and your grandfather was murdered and, someday somebody knocks on your door and says, hey, this was your grandfather's stuff, you can get it back. But if you're Jewish, you should have done something. And that's as best I can read this Bachelor decision. And the doctrine of laches is, ordinarily, it's if you see somebody buying something at an auction and you know that it's yours and you don't do anything and that person relies on your silence, it's unfair for you to be able to later assert your rights. That's the classic formulation of laches. But these cases have expanded it to cut off all rights, saying that someone unknowingly should have done something in a past life, and the situation for people wishing to recover artworks has been rendered since the Washington Conference very grim by this series of federal decisions undermining the common law right of private property.